Okay, Aaron, you may proceed with the program.
Okay, thank you everybody for joining us this morning for our a very interesting presentation on critical legal issues pertaining to NFTs. Our speaker is Mark Radcliffe, and I will be moderating. My name is Aaron Brav. I'm a corporate and intellectual property attorney based in Seattle. And just a little bit of housekeeping before we get going. Everybody's microphones will be muted and all webcams will be turned off to save our bandwidth. And if you have questions during the webinar, please send them to me through the chat function. And then I will collect them and kind of ask, pick the most popular ones and ask those, at the Q&A section at the end. And as a reminder also, this webinar is being recorded. And so with that, I will introduce Mark. Mark Radcliffe is a senior partner who practices corporate securities and intellectual property law at DLA Piper in their Silicon Valley office. He's worked both on transactions implementing blockchain technologies and NFT issues, and those two constitute a major part of his practice. He advised TikTok in their initial token drop, and he has been working with new technologies and business models for over 30 years, ranging from drafting the initial domain dispute resolution policy for network solutions in 1994 to developing the dual licensing model for open source startups. He is one of the co-chairs of DLA's Global Blockchain and Digital Asset Practice. And he's the co-author of Top Billings for NFTs, which was the cover article in the May issue of LA Lawyer magazine this year. And so with that, I will turn it over to Mark.
Thank you very much, Aaron. It's a pleasure to be here with the group, and I look forward to participating in discussion after I have the presentation. I think that non-fungible tokens are one of the most exciting technologies that I've seen in my over 30 years in Silicon Valley. And the reason they're exciting is because they enable new business models which wouldn't have been possible in the past, as well as accelerating existing business models. They also present a variety of legal issues that cross legal disciplines. So you have copyright, you have trademark, you have Article 2, you have licensing, and you even have securities laws. And in some cases, you may also have issues relating to guild contracts. So what I'm going to do is lay out the major issues which would apply to virtually all NFTs. And then I'm going to talk a little bit about what the open issues are. And finally, we're going to open up for questions. Just as a matter of context, NFTs last in 2021 were about a $22 billion industry. This year, things have slowed down, but in the first quarter, it was 12 billion in sales. Once again, there's a slowing to 8 billion in sales, but that's already 20 billion in the first half of the year compared to 22 billion last year. So it's growing dramatically. And my belief is that any consumer-facing company really needs to have an NFT strategy, and I'll discuss why a little bit later. So not only do NFTs enable new business models, but they also enable existing existing companies to have new revenue streams with their customers. For example, you have consumer products companies that are doing virtual products. So, and it's a lot cheaper, obviously, to produce a virtual Birkin or a virtual sneaker than it is to produce an actual tangible one. They also provide a challenge to some existing industries, particularly entertainment industries, from digital native companies like Yuga Labs. Yuga Labs, for those who are not familiar with it, is the company behind the Bored Ape Yacht Club, which only started last year, and it's a collection of 10,000 different what are called PFPs, profile pictures of apes. And they started out being sold for about $240. And I believe that the latest, what's called floor price, which means the minimum you'd have to pay, is over 120 ETH, which would mean it's on the order of $150,000. Business models do matter. There was a famous collection called CryptoPunks, where the rights of the owner of the CryptoPunk NFT were unclear. The CryptoPunks IP was bought by Yuga Labs, the people I just mentioned. They changed the licensing to IP rights to a more traditional commercial agreement, and the value of the collection went up dramatically because it clarified what people could do with their CryptoPunks NFTs. So once again, as I said, I believe that all consumer companies need to have an NFT strategy, whether you're an entertainment company, a sports team, or a consumer product company. So NFTs, your strategy will drive which legal issues are important. So there are collectibles, and that can include anything from what are called one-of-ones, which is a work of art that happens to be digital, through tickets to event or access to virtual experiences. The NFL included NFTs as part of the Super Bowl tickets. There's merchandise, both digital and tangible. For example, we're working with a team called Crawley Town in the UK, which is a soccer club, and there they partnered with Adidas to produce basically digital objects as well as tangible objects for their fan base. It can also be used for a tool for community coordination. For example, there's a project called Jenkins the Ballet, which is crowdsourcing a book. And I'm working with a company called Block of Horror, which is going to be basically, and crowdsourcing probably is not exactly the right term. It's essentially, it's a collaborative effort to write a book, just as Block of Horror is going to be a collaborative effort to write up and produce a feature film in the horror genre. And I think we're going to see more of those. It can help you develop communities and manage communities, and they can also be used as part of the addition of film, music, and films. So here's some example of major collections. I mentioned CryptoPunks, which is the group that increased dramatically in value when their license changed and people had a clear idea of what the rights were for 155 ETH. ETH is now about $1,300. And then Bored Ape Yacht Club, which is at 78 ETH, and Doodles, another collection at 9.2. Starbucks just announced a loyalty program that's going to be based on NFTs as well. And of course, NBA has been very successful with its Top Shot programs, which are collectibles of videos, which are otherwise available for free on YouTube and other venues on the internet, but which, because they're collectible and they have additional information, really have shot up in popularity and been very successful for them. So I like to analogize NFTs as a legal platypus. So a platypus, for those who are not familiar with it, is a very unusual mammal. And as we'll get into the NFTs, you'll see that they cover a lot of different areas. So the platypus is an egg-laying mammal. It's duck-billed, beaver-tailed, otter-footed, and has a poison spur. And the NFTs, you have copyright, trademark, Article 2 of the UCC, and I'll mention Article 12 of the UCC, which is a new article, licensing and securities law. So once again, you have a variety of different legal regimes applying to these. And I analogize securities law to the poison spur, because if you do trip over into securities law, you're going to be spending a lot of time and money on basically regulatory compliance. So let's talk a little bit about the major legal regimes which apply to NFTs. So first of all, you have copyright. For those who are not familiar with it, copyright are works of authorship which are fixed in a tangible medium expression. Include video, music, software, images, films. It's a very low threshold for protection. Although copyright law is national, there are over 180 countries have copyright laws, and there's an international treaty called the Berne Convention, which has tried to make the copyright laws more consistent. That being said, copyright laws vary pretty dramatically from country to country in certain areas, particularly in the US has what's called a common law regime, which is sort of economics based, whereas in Europe, they have a civil law regime, which is based on sort of the rights of the author. And that means, for example, moral rights are very important in the civil law jurisdictions like France and Germany and others, Japan and China, whereas economic rights are dominant in the common law regime, which is characteristic of the US and the UK and Australia and other British Commonwealth countries. But generally, the rights that you get as a copyright owner are the exclusive right to publicly perform, publicly display, reproduce, distribute, and make derivative works. And as you think about what you're trying to exploit, those are the types of rights that you need to think about. And we'll talk in the licensing section, those rights are pretty, your business model will determine which rights you choose to grant. So trademark is another major regime which applies in this area space. Trademarks are word, phrase, symbol, design, sound, or combination of these things that identify the source or quality of goods. For example, the roar of the MGM lion is a trademark. Word example is Apple. Design would be the Apple bitten the logo, which is of Apple, which is Apple, which has a bite taken out of it. So those are the sorts of things that are trademarks. Trademarks, once again, are national, but most countries provide rights only through registration, not use. The use rights, rights to trademark through use, are really only true in the US and other UK Commonwealth countries. And you need to think about that because, in many jurisdictions, there are people who are trademark pirates who make a very nice but rather unsavory living by registering other people's trademarks. So the reason that we have an Apple Watch rather than an iWatch is because a group of individuals in China noticed that Apple was announced a watch. And so there were like 6 different applications to register the term iWatch because China is a first to register country, and Apple decided that they didn't want to try to buy those rights back. And so now we have the Apple Watch, not the iWatch. So the owner of the trademark may prevent confusingly similar marks. And that confusion arises not only from how close the marks are, but how close the goods are. So you can have a Delta Airlines and a Delta Dental, because obviously dental services and airline services are not generally in one company. So you can have the same mark used in for different types of services, and also rights can vary by country. So for example, Harrods, the famous British department store, is protected in the UK by the Harrods department store there. They set up an operation in Brazil, which they eventually sold, and they also sold the Harrods trademark. So you have 2 different entities owning the word Harrods for exactly the same goods, retail services, but owned by different entities in different jurisdictions. Obviously, in the world of the internet, in the world of blockchain, which is fundamentally global, that can create some challenges. So trademarks are probably the most delicate right of all the intellectual property rights, because you must what's called police your mark. So first of all, to the extent that you license the mark, or to the extent that you use the mark yourself, you must monitor quality control and also police the use of confusingly similar marks. If you don't do that, over time, your Trademark could become very narrow. The more marks which are used for similar goods, which are similar to your mark, means that you have your mark becomes increasingly narrow in applicability, and at some point it even could become generic and not be enforceable. The example of that is elevator, who was once the mark for a particular brand of moving staircases. It's now the generic name for moving staircases. So if you're in New York, some of the older department stores have a plate at the bottom of the escalator, not elevator, escalator. They have the escalator brand moving staircase. Sorry about that. But I think the idea is clear that you need to police your mark. So what are the key legal regimes applying to NFTs? One that people don't think about as often they should is Article 2 of the Uniform Commercial Code. Article 2 of the Uniform Commercial Code governs transactions in goods, anything from automobiles to nuclear reactors. And I think, although it's never been held by a court, I think NFTs would be considered goods, particularly since software and other digital assets have been found to be goods. So why do we care? Well, remember, Article 2 is in the United States, so you'll have similar regimes overseas, at least potentially applying to this. But the reason you need to think about this is because any agreement between the seller of the NFT and the buyer is going to be governed by the UCC, and UCC imposes certain warranty terms, which, unless properly disclaimed, are included by default. Warranty of merchantability, which is average quality in trade, but only provided by merchants. And I think most people providing NFTs would be considered merchants. Fitness for a particular purpose. It's a little bit unclear how this would apply, but the example of fitness for a particular purpose would be if you sell somebody a pair of basketball sneakers when they've told you they're going to go climb Mount Kilimanjaro. Obviously, that's not fit for climbing Mount Kilimanjaro. Title, which should be interesting, warranty that you have title, as you may have read in the newspaper. There's been a lot of both scams and errors by NFT holders where they lost their NFT and had to buy it back from somebody. So when there's a transfer of rights in an NFT, the UCC2 would apply the warranty of title. And then non-infringement, another right which is which I think people would find very surprising if you're not familiar with the NFT. So with Article 2 of the UCC. So these are important rights. In addition, if you don't properly disclaim it, lost profits are one of the default damage remedies that you can get. So clearly, the Article 2 could significantly increase the liability of sellers of NFTs if you don't take appropriate steps. Article 12 of the UCC is a new article. It calls for rules of it's only approved this year. It has been sort of quasi-adopted by Iowa and New Hampshire. I say quasi because New Hampshire says we're going to adopt the final version, but their legislature only meets for a limited period of time. And so that's probably not going to become effective to next year. And Iowa adopted an earlier version of it. So it's obviously not adopted in many of the major commercial jurisdictions, but Article 12 are what are called controllable electronic records. It's meant to cover all types of digital assets, including cryptocurrency, non-fungible tokens, such as NFTs. And it creates this new category of controllable electronic record. It also controls, for example, digital notes. But a controllable electronic record is a record stored in an electronic medium that can be subject to control as provided in this section 12.105. It excludes certain types of electronic media, documents, as you can see, but nonetheless, it's very broad. Its key terms cover the priority of claimants to ownership rights. But in some cases, it may be subject to other laws. For example, the NFT may be subject to Article 2, which is a different regime vis-a-vis, for example, stolen goods. Governing law, it has a fairly elaborate set of default rules for choice of law. And once again, it hasn't been adopted very broadly, so it's probably of limited application now, but something you should be thinking about. Securities law is another important area that applies to NFTs. For those of you who are not securities lawyers, securities law in the US, and we're talking about US law right now, is both a federal and a state law. I'm going to focus on the federal law, but you need to think about state laws. I'll discuss a little more in the future. The federal law, particularly under the 1933 Act, basically focuses on disclosure, not fairness. That is not the philosophy of all state laws, but the key is, if it's a security, you have to disclose certain information. You could be take a look if you're selling to the general public, or there are certain exemptions for what are called accredited investors. But the key here is securities law. Securities are not simply common stock, preferred stock that you might buy on the New York Stock Exchange. They cover a wide range of things, from certain types of notes to what are called investment contracts. And investment contracts have been the issue which has been most at play when it comes to digital assets, particularly various types of tokens. You may recall that Telegram, the confidential messaging service, wanted to sell tokens on what they called their ton network. They're going to be called Gram tokens, but they were stopped by a court in New York because the court found that the tokens, even before they're issued, would be securities, and they would have been what are called investment contract. So investment contracts, the leading case in this area is in the Supreme Court's called the Howey case, and involves orange growth. So the key to understanding investment contracts is it's the manner in which the scheme or opportunity is discussed. It's not the underlying property. For example, the Howey test did not make orange growth or oranges securities. It made the manner in which Howey was packaging them a security. So it has 4 elements: investment of money, common enterprise, expectation of profits through the efforts of others. So pragmatically, you have to get all 4 of those. The first 2 are so common that they're rarely discussed. It's just that's common or virtually all situations. But the 2 that are important is expectation of profits through the efforts of others. And I won't go into detail on this, but there's a lot of people that focus on communities and decentralization as a way to avoid the idea that you're expecting profits through the efforts of others. But this is very controllable because if you are the NFT issuer and you start beating the drum about how this is going to be a great investment, it's just going to increase in value, you'll make a lot of money, you are squarely putting yourself in the sights of the SEC. And so you really need to think carefully about how you market your NFT project, lest you be ensnared in the securities law. The SEC has suggested that securities law may apply to NFTs. Hester Pierce, who is known as Crypto Mom, because she is the most sympathetic of all of the SEC commissioners to the crypto industry. Even she has said that in the context of NFTs, the definition of security can be very broad. They're particularly concerned about what's called fractionalization, where maybe somebody buys a single, CryptoPunk for 155 ETH, which would be about $200,000, and then sort of creates an entity to own it and sells, fractions of that entity. So now you don't own the NFT, you own a fraction of it. That sounds a lot like an investment or a collection of NFTs, where once again, where you sell interest in that collection, and also NFTs linked to royalty streams, other payments, and that's becoming something that's popular in the music industry, where you have this royalty stream, linked to a particular song or work, and you sell an NFT, and in that way, it accelerates the payment for the artist. But as I mentioned, securities law is not simply at the federal level. There are, basically state securities law in every state, and the state securities regulators can be more aggressive sometimes than the federal regulators. For example, there's a group that came up with an online casino, which they were trying to fund by selling what they called gambler NFTs, and they got cease and desist letters from Texas, Alabama, and Kentucky. And so, so you need to think about not just issues at the federal level, but also potentially at the state level. So licensing is an incredibly important part of the sort of monetization of NFTs, because if an NFT basically consists of a token on the blockchain, and then the artwork. Sometimes the artwork is on the blockchain. That's relatively rare because the artwork can, storage on the blockchain is quite expensive, and a large artwork, video or something like that would be very expensive to put on the blockchain. CryptoPunks, for example, is on the blockchain, but Bored Ape Yacht Club images are stored on an off-chain storage place. Sometimes, they range from a decentralized storage group called IPFC, Interplanetary File System, to Arweave, to even AWS. Well, but if all you have is a token and there's no license attached to it, you probably have virtually no rights. It's essentially like buying a book. And even the question of can you resell it is an interesting one, because there are cases that essentially say the first sale doctrine, which is an exception under copyright law to the distribution right, does not apply to digital embodiments. They have these cases go back, they have to do with software, but it suggests that if all you have is an NFT with no clarity on what the rights are, there's no license included, you have very limited rights. And so most NFTs now, particularly more recent ones, do come with some type of license. Sometimes the license is not very well drafted. The Bored Ape Yacht Club license has been criticized, I think correctly, for being very ambiguous. It's not clear if they're trying to sell the copyright in the particular image, or if they're just giving you a license to it, and they use terms like "you own it," where it's not clear what they mean by that, and yet they also have some restrictions on use, and that suggests that it's a license. So it's a big mess. If you want to take a look at licenses, which I think have been well thought through, I will mention a group of licenses which I worked on with Latham and Watkins and the General Counsel of A16 and Z Crypto. They're called the Can't Be Evil licenses. It's a set of template licenses similar to Creative Commons, with the idea of having licenses which are consistent and which give you various options. And they're also made available. We put them in the public domain so people can modify them as they choose. So one question that remains a major issue is if the token is sold, does the license go along with it? And if it does, how do you, how is that proved? And the reason this is important is because, as I said, there have been a number of situations where there's been a transfer of the actual token on the blockchain. The question is, did the license rights go with it? There was Seth Green, who's an actor, had a Bored Ape Yacht Club NFT, which he was going to use for the basis of the series. Somebody scammed him, transferred it, and then sold it to somebody. And the question was, well, did the intellectual property rights go along with those transfers because they were unauthorized? He decided just to pay some money and get it back. But that's an example of sort of the ambiguity of transfer. And that's one of the reasons you need a license agreement that deals with that issue. And you need to make clear that when when the token is transferred, the license rights are transferred, and then the question is, are there any what happens to any rights that were granted at the time, which I'll talk a little bit later when I talk about sub-license rights. So what about the right of the initial owner, Bay Area Yacht Club, or there's a group called Proof Collective, which did a series called Moonbirds. What rights they have to change the terms of the license? Well, if you have unless it's in the license, you probably don't have the rights to change it. And it's interesting, CryptoPunks, and once again, that was licensed by the Yuga Labs of the Bay Area Yacht Club, the fame, they kept the right to modify that license. And in the case of Proof Collective for Moonbirds, they went even further. And after granting a commercial license, they then put the copyrights of the Moonbird collections, once again, this another collection of 10,000 profile pictures, they put it into public domain using CCO. That's Creative Commons 0. It's basically a declaration that you're putting the copyright in the public domain. And that created a lot of heartburn in the community because a number of people in the community were in the midst of doing basically commercial deals. And then when their rights to the particular NFT disappeared, rather the artwork in the NFT disappeared, that created a lot of problems for them in doing a commercial transaction. CCO has been adopted by a number of projects. And of course, I think for the people on the phone, it's a little bit of a head scratcher. Why would you basically take your copyrights and put them in the public domain? And particularly when you could license them. Part of it is a Web3 sort of philosophy, I would say, which is that everything should be community-based. You want to, minimize the friction, and therefore any type of license is friction, and CCO is, makes the use of that particular artwork simpler, and therefore it'll become a meme, and therefore it will be more valuable. I think that remains to be seen. The other problem, of course, is it could be used for hate speech or propaganda, which has a negative effect on the brand. And I think it's important to note that the CCO designation, although it deals with the artwork, does not deal with the trademark. So you'll retain the trademark rights, or rather the project owner will retain the trademark rights even after a CCO declaration. There's also a theory that CCO is somewhat similar to great works of art who may now be in the public domain, but having the original work, whether you have a Van Gogh, or, is similar to having the original Moonbird, which is linked to your token, and therefore that has value. I think that remains to be seen, but it's one example of some of the business models that are enabled. And then one question that I think future developers will need to think about is, are you going to limit your ability to change the terms of the agreement or put the copyright in the public domain? Because obviously, as I mentioned, I think Moonbirds created a great deal of concern among the community. This happened only 2 or 3 months after Moonbirds were released, but nonetheless, people already had started working on commercial transactions, and it came as a very unwelcome surprise to them. But another question, once again, going to transfer, is what happens if you, as owner one of the NFT, have licensed certain rights to the artwork? Now you sell the NFT and the license to owner two. That is something that is just beginning to be considered. There's in some cases people taking the position, well, owner number two takes it subject to whatever rights were granted by owner number one. So this can be difficult to determine, but that's one approach. A second one is, and this is taken by the CryptoPunks license, which is whatever the sub-license rights are, continue, but if you have the right to modify, you're basically your modification right is terminated. You can, keep the right to reproduce and distribute, you can keep the right to the derivative works you created, but you cannot make a new derivative works. And then, another option is all the sub-licenses are terminated upon transfer. That's the position that the Can't Be Evil licenses chose, because that basically meant that owner number 2 would get full commercial rights without having the question mark of what rights did owner number 1 grant. Well, and we are continuing to see a lot of sort of poor understanding of copyright, I guess is the way to put it, or just simple mistakes. So a group called the Spice DAO paid $3 million for what's called a script Bible, which was basically a book, which would describe the making of a movie based on the book Dune. The movie is never made. It would have been, I think, 12 hours long and would have been extremely expensive. And it never, as I said, it was never made into a movie. And the Christie's who auctioned it thought that the script Bible would be worth about $40,000. Well, apparently the group that bought this, DAO, by the way, is a distributed autonomous organization, a group of people that have organized, come together, generally held together by tokens and a Discord channel, maybe even a Telegram channel, but it's very informal. What the effect of that is in the real world is uncertain. I think most attorneys believe, in the US at least, that if the DAO is not organized as a entity, it would be considered a default general partnership with all the disadvantages that go with that. But going back to the error, the people who bought it seem to think that by getting a tangible copy of the work, they would be able to make a movie based on the script Bible. And of course, that was extremely naive, because it didn't give them the rights in Dune. It didn't even give them rights under from Jodorowsky in the script Bible. So that group is struggling to find a reason that they paid $3 million for this, and we'll see what happens. Another dispute arose over the cover of the Reasonable Doubt album by Jay-Z. Damon Dash, who was a partner of Jay-Z and the owner of part of his record company, Rockefeller Records, sued to stop him because the ownership of the album was in Rockefeller Records, not in the individuals. And right now that case has been settled, but this is an example of who is the owner. It's not the individuals who have created it if they assign their rights to a corporation. So business strategies. So as you think about advising clients, I think, as I said, I think there's going to be a wide range of companies that need to have an NFT strategy. One is you need to be prepared to experiment with different strategies. There have been some examples of people sort of making an NFT because they can make an NFT. There's one toilet paper company that made an NFT of toilet paper, sold it without a lot of, thought about how that would tie into their user base. But, but I think more thoughtful companies like Starbucks, which is using NFTs to essentially, integrate with their preferred customer program, and probably going to provide additional rights to that, although that's just started. I think that's a more thoughtful approach, but you're probably going to have to take different approaches over time. A second one is you have to understand what rights you have. We had the example of Rockefeller Records, but you may also have more limited rights. Was a fight between, Miramax and the director of Pulp Fiction over who had rights to make NFTs of the handwritten script. And that fight was also settled, but what rights you have is going to be critical, and particularly for works with complex authorship histories. You're going to have to go back and figure out what rights you have and what you can use, because it may be that those rights were not included in the license grant that you got. Number three, you really need to monitor the NFT platforms. Right now, the marketplace is young, unsophisticated. Sometimes they don't understand intellectual property rights. Sometimes, frankly, they do understand, and they've just chosen to sort of leverage off other people's rights. And so this is an area where you may see a lot of infringements, and you have to be careful about keeping track of that. So, as I said, I think NFTs offer great opportunities for consumer companies, both for existing and new entrants, but that you need a structured and flexible strategy to undertake it here. So I'm happy to answer any questions. So I'll turn back to Aaron, and you can tell me what the questions are. So.
Yeah, thank you, Mark. That was fascinating. I learned a lot by listening to it, and we had a number of questions come in over the chat. So multiple people, including myself, are wondering about the securities law aspects of NFTs and where this might be heading. And what is your current practice in terms of advising clients that are looking to do an NFT drop? Is it, oh, you have to do this under Regulation D and everybody has to be an accredited investor? What's your practice, and kind of where do you see the law going?
Well, once again, it depends on the nature of the drop. So we're working with a number of companies that are going to be dropping NFTs that are attached to royalty streams for various works, mainly musical works. And in that case, we're taking the view that they're securities. We're looking at a Reg A offering, so we can sell to consumers, because obviously accredited investors is a relatively small market for some of these things. I would say that's a very small, at least currently, part of the NFT world. Most virtually all NFT projects view themselves as not being securities, I think, and good arguments can be made. I mean, I think it's very difficult to execute some of the strategies that people want to execute if you're limited to accredited investors. So to some degree, you're taking a risk, but once again, you can reduce that risk by the manner in which you discuss the opportunity, the manner in which you structure the opportunity. For example, the more you can make an NFT represent a community, rights to, for example, access to various online events, virtual events, and metaverse maybe even, the more you make it like a membership in a club, I think that dramatically reduces your risk that the securities law will apply. But the security laws themselves are frankly very ambiguous in this space. Commissioner Chairman actually Gensler has taken a very aggressive stance about what digital assets are securities. With his view is virtually all tokens, although he doesn't deal with NFTs, but he's talking about tokens for example, DeFi projects and stable coins, things like that. His view is virtually all of them are securities and should be registered. That has gotten a lot of pushback from the industry. It's also gotten pushback in Congress. There's a bill currently moving through Congress that would basically have digital assets regulated by the CFTC. So a lot of it is, in the securities law is essentially a risk analysis, and how do you minimize your risk with the understanding you're taking the risk, because in many cases, I said, you can't implement the business model if you think the NFTs are securities. So.
the next question is pertaining to the licensing model that you would advise clients to consider. And so, can you talk a little bit more about the project, for example, that you're doing with Latham, and trying to create kind of a standard set of licenses that that somebody can select from when doing their NFTs, and kind of what issues they should be thinking about?
Yeah, so I think the critical issue is what is it you're trying to achieve, right? So I think the major thing you need, well, I guess the first question you've got to have is, are you going to do a license, or are you going to do Creative Commons Zero? Yeah, I mentioned the challenges with Creative Commons Zero. I think you can achieve a similar effect with a very broad, non-exclusive license, but CC0 has become a trend, I would say, in projects. Many projects are using it from the beginning, but I think it's still a big question mark. And I would also mention that CC0 may not be effective in putting your copyrightable work in the public domain in many jurisdictions, because it doesn't, it's not just in the US. Let's say the project is located in the US, this has to be effective in jurisdictions throughout the world. There's a lot of ambiguity about putting stuff in the public domain, whether you can do it. There are certain countries like Germany where there's actually case law saying you probably can't contractually put articles in the public, put copyright works in the public domain. You also have issues like the fact that even if you put the copyrighted work in the public domain, particularly in civil law countries, it comes with moral rights, which are very difficult to exclude. So that's the first choice you have to make. The second choice would be, are you going to be granting commercial rights or personal rights? So the NBA, I recommend people take a look at Dapper Labs, take a look at Top Shots. They have very limited rights. Essentially, it's the right to publicly view, so public display or publicly perform the video clip and to sell it. You don't have the right to modify it. You don't have the right to sub-license it. And then at the other end of the spectrum, with commercial rights, for example, even though, as I said, the Bored Ape Yacht Club license is very poor, the new CryptoPunks license from the same people, Yuga Labs, is much better. But in the case of the Bored Ape Yacht Club, people are using it for a wide variety of commercial uses, everything from hoodies to wine to and it's also used to give people access to Yuga Labs events at conferences and things like that. Yuga Labs is also doing a metaverse project in which Yuga Labs will, the Bored Ape Yacht Club will be, NFTs will feature, and Bored Ape Yacht Club NFTs have been used in the book being produced by Jenkins LA project. So as a practical matter, those are the critical things that you need to think about. And then I guess the third issue would be, is it going to be exclusive or non-exclusive? I mean, some, in the Can't Be Evil licenses, we tried to, we had an exclusive license. Most of the licenses were non-exclusive. We also had a version of CCO. But the other question is, are you going to, and then I guess the last major issue would be, are you going to make the license terminable? Okay, so some licenses basically say, well, if you violate the terms of the license, it terminates. I think that's very dangerous. We've seen a real problem with that in the open source world with GPL v2 and GPL3 fixed that. But GPL v2, where you automatically lose your license if you violate the terms of GPL v2 are some very difficult to determine. And so compliance, even with the best intentions, is challenging. I think that leaves a lot of ambiguity. So we put in a more formalistic approach where the license can be terminated. And another issue is whether you're going to put in anti-hate speech. So there have been some sort of I would say artwork that has been appropriated by groups that you don't want to have part of your ecosystem. For example, Pepe the Frog has been taken over by a number of right-wing groups, which has proved to be very damaging, I think, to the ability to use it commercially. So those are the top level issue. Once again, I go to the A16Z website where you can take a look at the licenses. We've explained some of our choices there, and you can determine if those are right for you. And once again, if you you can modify them because we put them in the public domain.
So kind of a quick question for you is what's the best practice in terms of providing notice of the particular license that applies? Like, is that actually attached to the blockchain itself generally, or how do you let people know what the licensing terms are?
Well, that's one of the major issues, particularly because anything you put on the blockchain is going to be expensive from the point of view of just the cost of storage on the blockchain itself. I would say that in most cases, the license is in the metadata and linked to wherever the artwork is. But that's, and of course, that raises issues of, has the person seen the license? Are they bound by the terms if they haven't seen it? To which the practical response is, okay, let's walk that analysis through. Okay, you didn't see the license, you decide that you're not bound by it. Well, you don't have any rights then, because if you say that you didn't see the license, then once again, what you've got is similar to buying a book. You have the right, at least theoretically, to sell it. I mentioned the problems with resales in the digital space, but you certainly don't, if you say, I'm not bound by that license, well, you don't have the right to reproduce it, you don't have the right to make derivative works. So I think there's a practical aspect to this that, a lot of the cases, involving online terms and conditions are going to be relevant, but it's very difficult to comply with those obligations in the blockchain space, I would say.
So one final question before we wrap up, which is a topic that you didn't really hit on so much, but I'm curious about, which is the issue of liability, particularly if there's a smart contract that has a bug and does not achieve the intended purpose or is exploitable. How do you see that playing out in general, and also particularly in the NFT space?
Well, I think that is frankly one of the most challenging legal issues that we're facing right now. And it's not just bugs and smart contracts. It really applies to all software. There's very little case law about liability for mistakes in software, particularly tort liability. And it's a very important issue. Right now, there are a couple of what I think very damaging and ill-considered theories floating around. Professor Andrew Walsh has a theory that because major blockchains, she's thinking about Bitcoin and Ethereum, I think, these are public blockchains. She views them as sort of public utilities, and thus she thinks that developers of those blockchains should have fiduciary duty to users. Well, this, from my point of view, is a really unwise application of fiduciary duty, because I think the end result will be, particularly since most of these developers are working without pay because smart contracts are open source, you're applying a theory that doesn't really work. It doesn't work for a number of reasons, such as, okay, what's the scope of fiduciary duty? So if you're a developer, many of these code bases have thousands of developers. If you add 10 lines, and it's not your 10 lines that's the problem, are you liable, or is it only the person that added the 10 lines? And it's not easy to figure this out. People may remember the Toyota unanticipated acceleration cases. That went into a deep dive where they spent months looking at the Toyota code, trying to determine if there was something in code that caused it. And I don't think the special master ever came to a clear conclusion on that. But the net of it is, and the code's constantly changing. So you're talking about a tremendous amount of ambiguity without much, without, I think, having much of an effect on how developers operate. But this issue is actually, a real one right now. There's a person by the name of Craig Wright who claims to be Satoshi Nakamoto, the person who created Bitcoin. Although I think the number of people that believe he's Satoshi Nakamoto is limited to himself and his lawyers. There's a lot of skepticism. Anyway, he has sued the Bitcoin developers in the UK because he had a personal computer at home that was hacked, and he lost access to Bitcoin that's worth about $3 billion. And he is claiming that the Bitcoin developers have fiduciary duty to him to, first of all, not have permitted the hack, although it's not clear was due to a mistake in the code. But second of all, and that they should rewrite the code to permit him access to this Bitcoin. That case was dismissed at the trial court level. In the UK, you need to get the right to appeal. The trial court denied the right. The appellate court gave them the right. And I think it's going to be before the appellate court in December. That theory would be very, very damaging, I think, if it was created. So the answer to your question is nobody really knows what your liability is for mistakes in coding. Sort of another example of that is OFAC, the Office of Foreign Asset Control in the Department of Treasury, added Tornado Cash, which is a cryptocurrency mixer, to their list of denied entities. And even though it's a smart contract, it's not even an Ethereum address. But equally, and then the Dutch fiscal police arrested one of the developers of Tornado Cash. And so those seem to be linked, but we don't know. So right now, I think that is one of the most important issues in intellectual property law, and it could have repercussions well beyond the blockchain space.
Okay, we are out of time. Thank you very much, Mark, for the presentation, and for the audience. Recording of the presentation and the PowerPoint slides will be sent via email within 72 hours. And we'd also like to invite everybody to an upcoming event, which is the 4th Annual Artificial Intelligence and Robotics National Institute that will be held on October 10th to 11th. And so take a look at the ABA webpage for the details on that. And thank you, everybody, for attending.